When it comes to containing costs in healthcare, everyone has their 2 cents to give. But what do those of us in the business of health insurance have to say? This is Health Sense, and I'm your host, attorney Adam Russo, CEO and co-founder of the Phia Group, a firm with over 25 years experience navigating this ever-changing industry. Join me and my guests as we make sense of effective ways to reduce the skyrocketing cost of healthcare while improving quality outcomes for patients. The only thing it will cost you is 30 minutes of your time. So let's get right to the bottom line and reimagine what healthcare could be. Hello, everybody, and welcome to Health Sense with me, your host with the most, Adam Russo, the show that gets right to the bottom line on ways to reduce healthcare costs while improving quality outcomes for patients, as well as protecting your health plans. We are sponsored by the Phia Group, the leading cost containment firm in the country, focused on ensuring that everyone gets access to high-quality, low-cost care. And it's very important that everyone knows. Please tune in at 10 a.m., 6 p.m., and for you late-night owls that love to go out partying all night, when you come back from those bars, join us at 2 a.m. Eastern Time on Healthcare Now. That's capital N, capital O, capital W, radio. The main problem with healthcare in America can be tied back to Einstein's definition of insanity, doing the same thing over and over again, expecting a different result. That sort of reminds me of my Little League team. When I try to teach these kids something new, they keep trying the same thing over and over again, expecting not to strike out on a called third strike. Well, folks, that's also our current healthcare system. That's also the New York Mets, as our latest guest loves the New York Mets. We'll talk about that in a second. But the Mets, what do they always do, Ron? Keep spending more and more and more and more, expecting a different result.
Oh, no.
Yes, I had to do it. The word of the day is pace. Now, it's not pace yourself. It's not the pace car at the Indy 500, which has happened this past weekend. It's actually pace that is a service invented by your host with the most, as well as my guest, Ron E. Peck. Based on the positive feedback we received from our listening public, we are doing episode 2 of another 5-part series tied to compliance and legal issues facing self-funded plans and brokers. If you haven't guessed by now, he's only been at the Phia Group for roughly 20 years. He started off as just a, entry-level attorney with no experience, but now he is looked upon as the #1 ERISA expert in self-funded health benefit plans, our chief legal officer at the Phia Group, Mr. Ron E. Peck. Say hello, Ron.
Hello, Ron.
So, Ron, but you want to tell people what PACE stands for?
Yeah, so PACE is the plan-appointed claim evaluator, which, referencing the Mets, unfortunately, I've been a Mets evaluator, and my evaluation is they need some help. But they're not alone. Most benefit plans, I think, also need some help with their appeals and claims, and they need an evaluator, too. So PACE is here for them.
It was funny. I saw yesterday, I believe it was online, that how much money each MLB team spends per win. And my Cleveland Guardians are the most efficient spenders, about $837,000 per win, per game that they've won. I think the Mets are close to like $2 million or $2.5 million.
Adam, it's proof that you can't buy happiness, because I'm very sad.
That is true. Folks, for those of you that don't know, Ron has been a member of the Phia Group's team since 2006. As our CLO, he's been an innovative force in the drafting of improved benefit plan provisions. He's handled the most complex third-party recovery cases and is invaluable when it comes to healthcare direct contracting and spearheading efforts to combat the steadily, I didn't want to say steadily, rocket. It's like a rocket ship, increasing costs of healthcare. All right, Ron, there's a lot to cover. I know we got a bunch of cases that you want to go over today. So why don't you start us off with what you think is a really interesting case that most of our listeners will not fall asleep to today?
Yeah, sure. So I can't promise about the state of your listeners' sleep cycle, especially those who are listening to us at 2 a.m. Eastern time. But, when we last spoke, Adam, we talked about Schlichter and Bogart and these law firms that are filing lawsuits against broker advisors for fiduciary breach. And the reason we talked about it is, one, because these are new lawsuits that are being filed. Two, because some celebrities that are, in the healthcare space now. People like Mark Cuban are tweeting about it, right? And so it's in the crosshairs. People are aware of it. It's sexy, hot news, right? But what people don't necessarily understand or realize is that the ground was already fertile when these seeds were planted. We talked last time about how these law firms had approached things and filed similar lawsuits against broker advisors in the financial space for failing to administer the financial benefit plans, pension plans, 401ks adequately. And so they were accused of fiduciary breach there, and how these firms are now taking this decade-old cookie cutter and applying it now to health benefit plans. Well, that was what we talked about last time. But what we didn't really get into is that the health space has already been available. The door is open for people to sue entities that aren't on paper the fiduciary, but in reality are the fiduciary. Third-party administrators, insurance carriers, ASOs, brokers. Lawsuits like that existed already years ago. And, one of the cases that I like to look at is Doe versus United, all right, behavioral, which, again, this is a situation where you had an exclusion, it wasn't applied properly. The factors that led to the accusation of fiduciary breach are not as important as the fact that this case stood as an example that you can sue a third-party administrator, you can sue a broker advisor, even if they disclaim fiduciary liability in their contract, because they exercise fiduciary discretionary authority and they controlled the plan.
Well, you know what? It's interesting you say that, right? Because as an attorney, sometimes people have to just realize it's a business as well, right? So even though in many situations, I guess more logical, right, to look at it and go, well, if you have an administrator that administers 500 different plans, and those 500 different plans are 500 different self-funded employers, think about it. It'd be one thing to sue all 500 employers for not following their fiduciary duty. Right? Because the administrator, you're assuming, is processing all the claims for all 500 plans the same exact way. However, filing 500 lawsuits in potentially 50 different states is not pragmatic, right? It's not easy to do. It's always easier, if you can, if there's a way for you to sue the administrator, one entity, instead of 500 in one state, and you could still find a link that can show that even though the administrator says in their contracts and in their documents that they're not a fiduciary, if they act as one, if I'm an attorney, I want to go after them. It's much easier, right? Let's just make it simple. So I think that's probably one of the reasons why, even though it'd probably be easier from a legal argument to go after each individual self-funded health plan for breach of the fiduciary duty, pragmatically and economically, it's a lot easier just to go after the administrator if you could find a way to tie them in.
And, it's funny because the old saying, right? All roads lead to Rome, right? It feels like all roads lead to the broker. All roads lead to the TPA. And they really do, because as history, right? History has taught us, there have been instances where a plan participant, a beneficiary, a provider of healthcare services, they accuse the plan of having breached their fiduciary duty, either underpaying, denying a claim inappropriately. We hear a lot about the pre-certification process, right, where they have to get pre-approval and they're bogging down the system. All these different reasons why somebody has a complaint, and they go and they file a lawsuit against the plan. We've seen situations where the plan turns around and says, well, we don't make any decisions. Maybe on paper we're a plan administrator. ERISA required us to be the fiduciary, but in reality, we rely on our broker to tell us what to do. We rely on our third-party administrator to tell us what to do. And so we're going to turn around now the plan, and we're going to interplead, and we're going to pull in our TPA or broker, and they end up getting sued anyway. Vice versa, we've seen situations, the Baylor lawsuit, which is, a million years old at this point, but I remember when it was happening, where you had a provider that had a complaint about how a plan had been administered, how a plan had paid them, but they didn't sue the plan. They sued the third-party administrator. And it was the TPA who came out and said, listen, we're just a claims processor. You should be suing the plan. And that provider basically said, prove it in court, right? We don't believe you, we don't agree. And the court sided with the plaintiff, the hospital, the provider in that instance, and didn't let the TPA off the hook.
The case that Ron is referring to involves Baylor, which was the health system, and I think it was GPA, Group of Pension Administrators, was the TPA. And in that particular case, what had happened was the provider hired an audit firm to look to see if their claims were paid appropriately. Now remember, the claims payment, the money, was each individual plan's money. But the administrator, Group of Pension Administrators, they're the ones who actually process the claims. And what they found was that each of these claims was supposed to be paid in 30 days, 30 calendar days, but instead, some were paid in 31, 32, 33, 35 days, etc. And hence, the network discount that the plans were supposed to get was now null and void, meaning that the plans were supposed to pay full billed charges. And in that case, as Ron alluded to, the GPA, the administrator, even though all their contracts said they weren't the fiduciary, was found to be the fiduciary because, as they say, if it walks like a duck, quacks like a duck, then it's a duck. And I'll tell you, the crazy part that most people don't realize is that case really was almost the birth of reference-based pricing as we see today. It really is what caused it to explode, particularly in Texas, where that case came from. Ron?
And the thing is, it's interesting because, you and I, as attorneys who are in this industry, in the health benefits industry, sometimes we get bogged down by the facts. You know what they say? It's like, don't let the facts get in the way of a good story. And when we look at what does the law require, what do the contracts say, what does the plan document say? In that case, GPA was 100% correct. They say we're a third-party administrator. We're not the plan sponsor. It's not the plan. The plan is the payer. The plan administrator is the fiduciary, right? If there's an issue over how much should be paid, when it should be paid, it's the plan who ultimately is the one you should be going after. And what the provider said is, I don't care about the plan, right? I care about the network. It was about the network contract, not the plan document. It was about who's ultimately the big fish that we can go after, not what's appropriate on paper. And unfortunately, the court agreed with them. And to your point, this was a catalyst for a change in the way TPAs and those of us in the industry were thinking, which is that all of the logic, all of the laws, all of the statutes, all of the plan language that says you shouldn't be able to do this is out the window if it's inconvenient. And unfortunately, and again, this, like I said, was decades old. It laid the foundation for the types of lawsuits we're seeing today, where don't let the facts get in the way of a good story. Like I said, it's that, hey, I'm a plaintiff's attorney. Who can I go after? Who's got deep pockets? And can I link them in some way, fashion, or form to how the plan is being handled? And if I can, they're a fiduciary.
Folks, if you're just joining us here today on Health Sense with Adam Russo, today's guest is Ron Peck, the Chief Legal Officer at the Phia Group, and we are in episode 2 of our 5-part series tied to compliance and legal issues facing self-funded plans and brokers today. So back to this case and how that relates.
So I would tell you that this was a situation where the third-party administrator was being held responsible for a contract that was signed to benefit not the third-party administrator, but the plan. A network discount doesn't benefit the TPA. The network discount is a reduction in what needs to be paid by the plan. Furthermore, if you looked at the administrative services agreement, those plans were asking or authorizing the TPA to do so on their behalf. And yet it still came back to bite the TPA. You look at other situations, one of the famous cases that I like is Kraft Heinz. Big company. Now we're talking about a big employer, right? The last one I mentioned was Doe versus United Behavioral. They couldn't even name the plaintiffs there, right? It's Jane Doe, John Doe, Doe. But here we're talking about Kraft Heinz versus Aetna. Talk about big names, right? Everybody knows these. And again, this was a situation where Aetna was accused of various wrongdoing, the way they were processing claims. I'm not going to get into the weeds on what they were accused of. But what's important, again, is that Aetna, and they have excellent attorneys and excellent legal arguments. They're basically coming out and saying, look, we're not a fiduciary. Here's what we do. It's procedural, it's processing, it's clerical. Ultimately, we shouldn't be held liable for the things that the plan is A, legally responsible for, and B, authorized, right? They were benefiting from these different practices until they weren't. Now that they're unhappy, they're going to come after us. And even then, you have a court that, without deciding whether they were liable for the issues or damages they were accused of causing, at least stated that, yes, they can be sued as a fiduciary in the first place. And Adam, I think what all of these cases teach us, ultimately, if you want to boil it down to sort of what's the lesson here, right? What do you really want to take from this? Is that anybody can be sued for anything, anytime. We say that all the time, right? Can you prove it? That's one thing. But can you initiate the lawsuit in the first place? Absolutely. And it's very hard to avoid. That's number one. Number two, it's very hard to be an excellent service provider and at the same time avoid all possible liability. Because if you're somebody who refuses to make decisions, refuses to provide guidance, refuses to give advice, right, isn't somebody that your client can rely upon. Oh, well, I don't want to say, I wouldn't want to dictate anything for you. I don't want to influence your decision. Well, then what am I paying you to do? Right? So we run into this issue where if you are so dead set on avoiding liability altogether and you don't want to be a fiduciary, then the chances are you're also reducing the value that you present to your client. So maybe, and I'm just going to throw this out there, PACE, like you mentioned, it might be time to actually embrace the liability, take on some responsibility, be willing to face the accusation of fiduciary status, and in turn, provide something of real value to your client.
Responsibility.
Sure. So if you look at self-funded benefit plans and ERISA, right? So this federal law, the Employee Retirement and Income Security Act, that dictates what a plan administrator, a plan sponsor is responsible to do ultimately for its benefit plan and all the people, all the employees, the plan members, their families that are part of this plan. It boils down to something very, very simple, right? One, be prudent with the plan assets. Two, enforce the terms of the plan as they're written. And three, no self-dealing, don't be corrupt, be honest, be transparent, be good. That's it. Very simple. So as a plan sponsor, okay, as the plan administrator, and again, ERISA requires the plan sponsor to identify someone who serves as that plan administrator, serves as that fiduciary. As that fiduciary of the plan, I would argue that doesn't mean it's your responsibility to do everything, because nobody can do everything, right? You've heard the term jack of all trades, master of none. If I want the plan to be administered as effectively and efficiently as possible, it behooves me to find experts, specialists in all the different areas of plan administration to assist me, to aid me, to share that responsibility. If I don't know how to write a plan document and I go and try to do it myself, it's going to be a bad plan document. I, by not seeking assistance, by trying to do it myself, have arguably breached my fiduciary duty to create a legal plan document. Likewise, if I don't know how to process medical claims, right, it behooves me to find somebody who can. If I don't know how to subrogate or pursue liable third-party payers and get money back for the plan, I'm leaving money on the table. Sounds like a breach of my fiduciary duty. I better go find somebody who can do subrogation. So I would argue that the plan administrator that is identified by the plan to be fiduciary number one, right, patient zero, your job isn't to do everything. Your job is to find capable entities who can assist you with those various tasks.
But let's not forget, Ron, so even though I'm getting assistance, so let's say an appeal comes in and I review the appeal and I'm like, I'm not an expert, I'm not a doctor, I'm not a surgeon. I can't make a decision as to whether or not this was medically necessary. So I hire a third party. Plenty of companies out there that you could hire to do clinical reviews, right? And they come back and they say, it's not payable. I, as the fiduciary, am seeking assistance, but ultimately I can say, you know what? I don't agree. I want to pay that claim because the responsibility lies with me. So having the assistance of third parties doesn't transfer that third party fiduciary responsibility to another party. However, with PACE, one of the things that you're saying that Phia has and does via an offering would be in a situation where you have a final level appeal, having a third party take on the responsibility of making that decision and why that might make sense. And I'm going to throw you maybe a curveball here. Let's say I'm the plan sponsor, right? Or we have a committee of 3 people that are the plan sponsors that we vote on things. And it's an employee that we all know. All 3 of us know this employee. They've been working at the company for 20 years, knock on wood, or 15 years. And we love them. They're a great person. And they require a surgery that may or may not be medically necessary, right? You don't know. It might not be covered by the plan. Just emotionally, we don't feel comfortable making that decision because we have to look at this person every single day when we walk into work. Having an independent third party become the fiduciary in certain situations to make an independent decision that's not taken into account. We love this guy. We love this woman. She's a great employee. She's one of our family members. Let's be honest. When someone is close to you, your decision making could be a little flawed or tainted because of that relationship. What are your thoughts about that?
Oh my gosh, there is so much to unpack there. So let's start from the top. Number one, when it comes to the concept of, a fiduciary where somebody comes in, they tell me something, and I say, well, I'm going to ignore you and do it differently, right? Fiduciary status, I always like the joke, is like COVID, where, I could be a fiduciary, cough on you. It doesn't mean that I'm not a fiduciary anymore. Now it means you are too, right? So it can be spread and replicated. That's number one.
I like
So
that.
it's important to note that. Number two, right? The moment that I exercise some sort of discretionary authority or control over the plan in a way that is different than your advice, than your suggestion, than when you told me to do, I've basically cured you of that disease, right? That idea of proximate causation. It's that you may have done something negligent, but if my negligence sort of stepped in the way of you and the end result, now it's on me, not on you. So if you gave me bad advice or you gave me good advice and I just ignore you altogether and do what I want to do, and something bad happens as a result, you're off the hook. So it's that idea of control. Note that in a lot of the lawsuits we're talking about here today, Adam, in all of these instances where we're talking about a TPA or a broker or your brother's cousin's uncle's in-law, it doesn't matter who they are. What matters is what their influence or power is over you. If somebody tells you you should deny the claim, and they don't tell you why, they don't give you any information, they don't give you any evidence to back their decision, and you go, whatever you say, I'll do. You've handed the keys over to them. You've given them the power over the plan. That is a hallmark of fiduciary authority. If they go and they say, here's the reason why I would tell you to deny the claim, or here's the reason why I would tell you to pay the claim, here's what I would consider, but you need to make your own decision. Go ahead and assess it yourself. Now what I'm trying to do is I'm trying to avoid fiduciary liability or duty. With PACE, it falls somewhere in the middle, where what you're looking at in a situation, and again, for those who don't know, PACE, it's basically when these appeals come in, the plan farms it out to the Phia group. Phia looks at it, issues a directive, whether to pay or not. With that type of situation, that directive, it includes the rationale. It includes the evidence, right? It's not just a pay, black box, don't ask questions, just do what I tell you to do. But they're accepting liability. They're accepting fiduciary liability. You have to understand, the plan administrator, plan sponsor, is still a fiduciary. Even though the PACE is a fiduciary now as well, like I said, it's been multiplied. It didn't take it away. So in addition to being a fiduciary, we also have to indemnify the plan. So it's A, I'm liable, and B, I'll make sure you're not, right? And when you talk about the conflict, whole nother issue, very important, on top of, are you a good fiduciary? You don't want someone, even if you made the right decision, ultimately, you could still be held responsible for fiduciary breach if someone can argue that there's a conflict of interest there, that there's bias, that there's discrimination. To your point, I have two employees, one who's new, nobody knows the person, nobody cares about the person. They come in, they have an expensive procedure that they need. We go ahead and we deny it in accordance with the terms of the plan. That sets precedent. Now somebody's been with the company for 15, 20 years. They come in, they're important to us, they're valuable to us, same exact procedure. We want to go and pay it. Now, not only by paying those claims, am I potentially violating the terms of the plan in a vacuum as it relates to that specific claim, but I'm also potentially discriminating against the person whose claim I denied by not upholding the precedent. So having a third party come in not only ensures that you're staying consistent, right, but it also eliminates even the illusion of conflict of interest.
And I think that's the key right there.
It is. It's the perception.
One of the key things we didn't bring up, though, is also, as many people know, most self-funded plans, including ours, we could not be self-funded if we didn't have stop-loss coverage, the catastrophic coverage for the extremely rare but really big claim, like $1 million claim, $500,000 claim. And in those situations, it's perception's reality. If you advise to pay a claim, remember, you have to get stop-loss now to actually want to reimburse that claim. Much easier to do if it's an independent third party with no skin in the game making that decision versus somebody within your HR department. So Ron, this has been absolutely great. I know we brought up 3 cases and we talked a lot, but we've just run out of time. Any last minute thoughts, anything you want to share tied to any of the cases, just things that we want brokers and our audience at large to know when it comes to fiduciary risk and how that risk can be transferred or mitigated in most situations?
Yeah, I'll tell you. Number one, it's not new, right? The concept of fiduciary liability, fiduciary status has been around as long as a risk, even longer. That's number one. Number two, Fiduciary status or liability may not necessarily be something you want to avoid. It's something that you might want to embrace, but in a controlled environment. It's better to dictate what your fiduciary duties are and what your liability is up front than wait for a plaintiff's attorney to accuse you of fiduciary liability when you were trying to avoid it. That's number 2. Number 3, the types of cases we're talking about, and there's plenty of them, way more than we could cover. These lawsuits, this litigation has been around for a long time. And one of the fundamental foundational concepts behind all of these fiduciary lawsuits is not only did you make a mistake, but it benefited you to do so. That concept of self-dealing, of discrimination, of conflict of interest, that's the kicker. That's the smoking gun, right? You know, it's like they say in those murder documentaries, is what was the reason, right? What was the cause? What was, you know, it's like, we know they did it, but we can't figure out the reason why. That is what the jury wants to hear, is why'd they do it? And the argument is, well, because any dollars they saved stayed in their pocket. And this is true whether you're talking about self-funding or traditional insurance. If you deny it, you keep the money. So having a third party who, to your point, doesn't have any skin in the game is a way to get around that. So it's all about creativity. These arguments are old, the concept is old, but the rationale, the new arguments, the new accusations are new, where they're coming after broker advisors instead of just TPAs, right? Where they're accusing them of telling the plan what to do and it being a mistake or bad advice. This is a newer concept. So learn from the past, prepare for the future, and try to avoid any illusion or perception that you have violated ERISA or violated a fiduciary duty because of a conflict or anything like that. Stay squeaky clean, document everything, provide proof, and you should be okay.
Well, folks, that's all the time we have for today. Ron, awesome insight. Here's what we know. Lawyers will always find something new to sue on. We know that. I just can't wait 5 years from now when they start going after all the AI companies because people started doing things based on what AI told them to do, and it didn't quite work out. That's the next thing I can see. Folks, thank you so much for joining Ron Peck. We'll be back with episode 3 in a few weeks. On behalf of Ron and myself, thank you for joining us on Health Sense on Healthcare Now Radio. And as always, let's go Cleveland Guardians. Have a great day.